Notice to public servants, a legal assertion of sovereign rights. This document serves as a formal notice to public servants, emphasizing the legal basis for asserting individual sovereignty and the protection of constitutional rights under U.S. law. The following content outlines statutes, case law, and constitutional provisions that support the bearer's claims. Legal foundations of sovereign rights. The bearer, as an unenfranchised sovereign, operates under the authority of statutes from the First Congress, 1789, Articles of Confederation, 1781, and specific sections of the United States Code, USC, including Title 18, Section 241, and Title 42, Sections 1983, 1985, and 1986. These legal references affirm the right to unhampered use of navigable waters, common law highways, and public roadways for private, public, or commercial transport across the United States. The bearer is bound to uphold the U.S. Constitution and can only be lawfully detained upon a sworn complaint from an injured party, as stipulated in the Fourth Amendment and common law principles. As a sovereign citizen of Colorado, the undersigned rejects the contractual obligations implied by motor vehicle codes and claims exemption via the Uniform Commercial Code, UCC, provisions. Driver's license and legal identity. The driver's license issued under duress by the state of Colorado does not legally bind the bearer as a secured party concerning the name listed in all capital letters. This distinction is critical in asserting that the license is not a valid contractual document obligating compliance with state motor vehicle codes. Case law supporting the right to travel. Multiple Supreme Court decisions affirm the constitutional right to travel, including Williams V, Fears, 1900, and United States v. Guest, 1968, recognizing freedom of movement as a basic constitutional right. Meyer v. Nebraska, 1923, and Roe v. Wade, 1973, which extend personal liberty to include travel. Crandall v. Nevada, 1867, which invalidated state-imposed travel taxes. These cases collectively establish that licensing, registration, and mandatory insurance laws may constitute unconstitutional restrictions on the right to travel. Statutory and constitutional violations. The imposition of licensing requirements and related regulations is challenged as a violation of constitutional protections, including the Fifth Amendment's protection against deprivation of liberty without due process, the 14th Amendment's guarantee of equal protection under the law, provisions against unlawful search and seizure under the Fourth Amendment. Legal definitions and interpretations. Legal definitions from Black's Law Dictionary and case law clarify the distinction between rights and privileges. For example, a license is defined as a permission granted to do something otherwise unlawful, not a requirement for exercising fundamental rights. Littleton v. Burris, 1904. The right to travel is not a privilege that can be regulated by the state but a fundamental constitutional right. Thompson v. Smith, 1930. Potential legal violations by public officials. This notice outlines potential federal offenses applicable to public officials who enforce unconstitutional laws, including conspiracy against rights, 18 U.S.C. 241. Deprivation of rights under color of law, 18 U.S.C. 242. RAC,